What can you do in a home invasion in Texas? Imagine this, you're at home with your family and someone is attempting to break into your house or actually breaks into your house. What can you do and be legally justified? Can you use self-defense? Can you use deadly force? What's the Castle Doctrine in Texas? What does stand your ground really mean? And what should you expect if you have to use deadly force? Let's also talk about something that may be the most overlooked part about the self-defense law or the Castle Doctrine in Texas. If you were to look at the Texas Penal Code and search for the Castle Doctrine or stand your ground, you are not going to find those terms. Nonetheless, Texas is, and it probably comes as no surprise, a Castle Doctrine state and a stand your ground state. So let's talk about what that means. The Castle Doctrine in Texas creates a presumption about the use of force under certain circumstances. There's certain qualifying conditions. One, we have to be in your castle. And here your castle includes your residence, place of work, and your vehicle. Oftentimes, people don't know that their place of work or employment is considered part of their castle. It is a place you are lawfully allowed to be and is specifically provided for under 9.31 and 9.32 of the Texas Penal Code of places where the Castle Doctrine applies. The next condition can be met a number of ways, so let's take each one in turn. The first way to say that the Castle Doctrine applied is to have a scenario where someone is making unlawful entry or attempted entry into your castle using force, and that last part's going to be important. So it doesn't have to be that the person made actual entry. It can even be the attempted entry. So they're at your front door, you see them trying to jimmy the lock or make some sort of forced entry, they've broken a window, they haven't actually entered your place of business yet, but they're about to, they're reaching in to try to open a door perhaps. Those are scenarios where the Castle Doctrine might apply, but remember the last part of that, using force. So if you leave your door unlocked and they just walk in without permission, that may be unlawful, but they haven't entered with force. And the common example and the most frequent question we get is, what if I put up criminal trespass warnings, or I use the purple paint to notify people that trespassing is not permitted on my property, or they're simply on my property, they jumped a fence and they got over. Well, under this fact scenario, prosecutors, detectives, and police officers are going to say, you don't have any proof that this person entered by force. Now, of course, we can all come up with examples of how we might show force was being used. You might have a camera. There might be something else that shows force was used. But remember, that's part of this version of getting the Castle Doctrine to apply. Don't forget that you have to use with force. I know a lot of us want to believe that if someone simply enters my property, I can pull out a gun and shoot them. That's not exactly what the law says in Texas, and you need to be aware of that. So unlawful entry or attempted entry, but it has to be using force. The next way you can establish the application of the Castle Doctrine is to show that the person was trying to remove you by force from your castle. Now, in this scenario, you don't have to show that the entry was unlawful. You don't have to show that the entry was with force. It's a completely separate way to establish the Castle Doctrine, which is to say, someone tried to remove me from my home, my business, or my vehicle using force. Now you get the protections of the Castle Doctrine in Texas. Notice here, the law doesn't require them to be successful in getting you out of your car, home, or business. It's their attempt to remove you from your castle that gives you a basis to use the Castle Doctrine. A third way to establish the Castle Doctrine's application in Texas is to show that the person you used force against was committing or attempting to commit certain types of offenses. Specifically, if they're committing or attempting to commit any of the following offenses: aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery, those are all instances where you can use the Castle Doctrine. So let's say there's an example of someone who has made entry into your home. Maybe it's that scenario where you forgot to lock the front door. It was not forced entry. There's no proof that it was unlawful, but you have reason to believe that they were there to commit one of these offenses. Then you could use the protections of the Castle Doctrine. To use an example of an actual case I worked on, it was a young lady who lived in Fort Worth who woke up in the middle of the night with a male figure standing over her bed. Well, it turns out that she had forgotten to lock her apartment door. This person walked in and was standing right above her as she was sleeping. In that scenario, if she used force or deadly force to protect herself, she would get the protections of the Castle Doctrine if she had a reasonable belief that this person was there to commit the offense of sexual assault. So a lot of this comes down to what are the specific facts that apply. And if you're in a scenario where you forgot to lock the front door, they've made entry, the takeaway is if you have reason to believe they were there to commit one of these serious offenses, then you get the protections of the Castle Doctrine. But more importantly, if you have to use force or deadly force to protect yourself, your castle, your family, it is so important that you talk to an attorney before you give any statements to the police. That's your second biggest takeaway, and equally important, because if when you're talking to the police in the moment after this happened, you're probably not thinking with a clear mind, and certainly you're not recalling everything we talked about in this video or what the penal code looks like. When you contact the police, you need to tell them to come out, identify yourself, say as quickly as possible you had to use self-defense, and leave it at that. Don't give any additional statements. You want to tell them enough so that they don't come out there and think you're the bad guy, that you're safe and someone they don't need to draw arms on. And then they can do their investigation. When they ask to speak to you, which they will, tell them you will talk to an attorney and cooperate with their investigation. But you're in no mindset to be giving statements because frankly, you won't know what to say to best protect yourself. The Castle Doctrine and our laws regarding self-defense in Texas are very strong, but you need to know how to take advantage of them. And the best way to do that is to make sure you talk to an attorney and let any statements you give come through that attorney or with the attorney sitting there beside you. A lot of you watching this video may be very familiar with the self-defense laws that apply in Texas and even the Castle Doctrine. And maybe you're watching this to see if I got it right and you want to send it to your friends who might need more education on this topic. But I'm going to cover something that I never see anyone cover, but comes up in court regularly. And those are instances where you cannot use the protections provided to you under the Castle Doctrine or any of the self-defense laws in Texas. And this is something you need to take to heart. There are three main things that will keep you from using the self-defense protections in Texas. The first way that the self-defense and Castle Doctrine protections can be taken away from you is if you were the aggressor. So sometimes people think, well, if I got the worst end of the assault, then I can claim I was acting in self-defense. That's not true. If you're the person that was the aggressor or started the physical altercation, then you cannot use self-defense. And I say physical altercation because Texas also says that verbal provocation is not sufficient for a person to use physical force in defense. But when we're talking about two people that are engaging in a fight, excluding mutual combat situations, you cannot claim self-defense if you were the aggressor. And an easier way to say that is if you're the person that started the physical fight. A second way to lose the protections of the Castle Doctrine or self-defense in Texas is very closely related to the first example, which is you can't be the aggressor. The second way is you can't provoke the difficulty or you can't provoke the attack. So if you're doing something that creates the scenario that you then try to claim is the basis for your use of self-defense or Castle Doctrine, that's going to get rejected. Somewhat hard to come up with an example because it's so closely tied to, hey, you can't be the aggressor. So if you at least remember you can't be the aggressor, you'll be pretty well off for those first two ways to lose the protections of the Castle Doctrine or self-defense. The third way to lose the protections of the Castle Doctrine and self-defense in Texas is to otherwise be committing a criminal act. And this comes up with great regularity. There are some easy common sense examples. If you're in your car and someone draws a weapon on you, you can't claim that you're protected by the Castle Doctrine or you're using self-defense if you were in that car and they were in that car with you or next to your car to do a drug deal. You were committing a criminal offense. Now you can't claim that you were able to use the protection of the law while you were breaking the law to use self-defense, use deadly force, or claim that you were protected by the Castle Doctrine. But understand that example can be stretched pretty far. We've had situations where prosecutors argued a person lost their ability to claim they were acting in self-defense for nothing more than a small amount of marijuana in their pocket. Most people don't consider marijuana possession to be an extremely serious offense. In Texas, even under 2 ounces, it's a misdemeanor offense. Even that low-level offense, so we're excluding traffic offenses that would be punishable by a ticket, but essentially any other offense will keep you from being able to use self-defense or the Castle Doctrine. Lots of people in Texas have things in their homes that might be illegal. This comes up with greater frequency every passing year because now, as surrounding states and even our neighbor to the south, Mexico, legalizes or decriminalizes marijuana, you see more and more people that have small amounts of marijuana in their home. But imagine this scenario. Someone's breaking into your home and a prosecutor's arguing, hey, you don't get to use self-defense or the Castle Doctrine because the law says you can't be committing any other offense. So now that misdemeanor possession of marijuana that wasn't bothering anyone is resulting in you potentially facing an aggravated assault deadly weapon charge, or even worse, a murder charge. And prosecutors, even prosecutors here locally, absolutely go down this road and they try to exclude people from being able to get the protections of the Castle Doctrine and self-defense in Texas. So be very careful when you're using self-defense. And again, what's happening immediately after your use of self-defense? After you call 911, you need to speak to an attorney as quickly as possible. I would also recommend that you immediately record the scene and not provide that to anyone other than your lawyer. If that ends up being helpful for you, then that's something your lawyer can use. On the other hand, you should not volunteer that information or give it to the police without an attorney reviewing it because you don't know what you have just captured on film. It might be something that's very helpful. It might be something that hurts you. So your takeaways are: know the 3 things that will keep you from using self-defense or being able to claim that you were protected by the Castle Doctrine in Texas, and be sure you contact an attorney. There are lots of great Second Amendment insurance providers out there that provide insurance for just this type of thing. I'm not affiliated with any particular one. We've handled cases for lots of them. The advantage there is if you have to draw a weapon, use self-defense, use the threat of deadly force or actual deadly force, all of those things are going to be covered, depending on your policy and the provider you're with, in a scenario like this, and you can then hire an attorney without worrying about how much it costs. So I tell my family, I tell my friends, that is a worthwhile investment. And I'm not pushing or promoting any one company. It's something you should look into if you own a firearm and there's a possibility that you might have to use deadly force in your home, in your car, or in your business. If you liked this video or found it to be helpful, be sure to share it with your friends. There's a lot of misinformation out there about your Second Amendment rights, when you can use it and when you might be limited from using it. So this is valuable information to share, and the more we can get the word out, the better people can be about using deadly force or self-defense or the Castle Doctrine properly in Texas.